What if I told you that some people go through the stress of filing bankruptcy only to have their case thrown out before they ever get the relief that they needed? That can be one of the most frustrating things that can happen in a bankruptcy case, but it's avoidable. Hi, I'm Perlman. I'm a consumer bankruptcy attorney. I've been helping people get the financial fresh start they deserve for over 30 years. Before we talk about why a bankruptcy would be dismissed, I want you to know that reaching out to a bankruptcy lawyer does not mean you're filing bankruptcy. It simply means you're trying to understand what your options are. If you find this video helpful, make sure to like, share, and subscribe, and contact our office if you have any questions. When people hear the word dismissed, what that usually means is the bankruptcy didn't proceed in the way that it should have, and that individual or the debtor didn't get the relief that they had hoped for. One of the biggest reasons is because of simple paperwork problems. Bankruptcy requires full, accurate disclosure of your income, expenses, debts, assets, and financial history. If tax returns are not submitted or filed timely, or your debts aren't scheduled properly, the court has the ability to dismiss your case. Even small errors can create major problems, making your filing look incomplete. Another major issue is failing to complete the required credit counseling or debtor education courses. In almost every consumer case, a credit counseling class must be completed prior to the time you file your petition. And your debtor education must be completed after your case is filed, but prior to your discharge being entered. If those courses are not taken by United States Trustee approved providers, or they're not uploaded to the court docket correctly, your case can also be dismissed. This is a technical requirement that sounds minor, but it's really consequential and can impact your ability to get your discharge. A bankruptcy can also be dismissed if you fail to cooperate with the trustee or the court. After filing, in some cases, you may be asked for additional documents or a further explanation about your testimony, for example. You also have to attend the required 341 meeting of creditors. If you want more information about how the 341 meeting works, you can watch my video here. If you ignore these requests, miss deadlines, or fail to appear, your case can be dismissed. Eligibility is another big reason that your case could be dismissed. If someone files Chapter 7 and does not qualify, this could result in a dismissal if the United States trustee files a motion or the trustee seeks to dismiss your case for cause. For example, they may fail the means test. The means test is designed to determine whether the debtor actually qualifies for Chapter 7. Timing also matters. If you file too soon after a prior case, that can result in the dismissal or ineligibility for discharge. Then there is the issue of payment. Many times people fail to pay their required court filing fees. The process is not free. If the filing fees aren't paid when they're due, your case can be dismissed. And finally, one of the most serious reasons that we have seen a bankruptcy can be dismissed is because of dishonesty with the court or dishonesty in disclosures in your schedules. If someone hides assets, lies about their income, forgets to include debts, transfers property to friends or family, the court can dismiss their case at any time and sometimes can even impose fines or criminal penalties. In some situations, a dismissal can be even more serious because there are limitations about how and when you can file another bankruptcy after your case has been dismissed. Certain dismissals can come with what's called a bar, usually for 180 days, and in certain situations, there can be additional restrictions on when you can file again. The good news is this: a lot of dismissals are preventable. When the case is prepared the right way, you are more likely to get to the finish line, which is the discharge. My name is Perlman. I'm a consumer bankruptcy attorney. If you're thinking about filing, please contact our office so you can understand what your rights are. Remember, reaching out to a bankruptcy lawyer doesn't necessarily mean you're filing bankruptcy. It simply means you're trying to understand what your options are.